Why did the defense request a jury instruction on uncalled witnesses? I'm going to explain that here in just a moment with some case law. Hi, Tony DeWitt here. I'm a Missouri appellate attorney, retired, and I bring you a fresh perspective on the law without offering any legal advice. So pull up a chair. This is what we're discussing today. Stay tuned at the end of this video because I have a question I need to ask about a series of videos I want to do. So I'd appreciate it if you hang in there or, if you get bored, jump to the end because I really would like an answer to this question. Whenever a party has the burden of production and persuasion, meaning, of course, the duty to present witnesses as well as to have those witnesses give persuasive testimony, when that party fails to produce a witness at trial, then they bear the brunt of the failure to do so. But in this case, the state could have produced three additional witnesses: Brian Higgins, Brian Albert, and Trooper Proctor, or perhaps I should say former Trooper Proctor. This is the sort of the unholy trinity of cops who could have but did not testify in the trial. They did testify in the previous trial, so it would appear that there is strategic reasons for them not to be called, and I'm sure that's what they're going to argue. With regard to Trooper Proctor, you could certainly understand that there would be a strategic reason not to put him on the stand because of those horrible text messages and because of the sophomoric decisions that he made as the lead investigator, the trooper investigating this crime. He would have been subject to cross examination again, and it would likely have turned out the way it did in the first trial, with him looking like the north end of a southbound horse. Would have likely discredited him with the jury, and with him and his investigation go the chances for the Commonwealth in this trial. Because there could be a valid strategic reason not to call Proctor, a court might not allow the use of the instruction. But as to Higgins and Albert, clearly those folks have information valuable to the state and to the defense, and there is no reason, logical or otherwise, that would for them not to call them, other than that they'd hurt the Commonwealth's case. But the case law in Massachusetts, which is the worst state for criminal law in the country, is terrible on this issue. Commonwealth versus Williams is a 2016 Supreme Judicial Court decision. Williams was convicted of first-degree murder, and at trial the defense sought a missing witness instruction regarding one Evangelista, whom the Commonwealth chose not to call. Evangelista was a potential witness but was under indictment in another county, and the prosecution avoided using him. The trial judge denied the instruction and forbade any reference to Evangelista's absence in closing argument. So, the defendant requested this missing witness instruction, arguing that the jury should infer from his testimony would be unfavorable to the prosecution. The judge refused to give it. And the appellate ruling, the Supreme Court upheld the trial court's decision, finding no abuse of discretion. The court noted that the Commonwealth had a legitimate tactical reason for not calling Evangelista. He was himself facing charges elsewhere. Supreme Court reiterated the strict standard for such charges. A missing witness instruction is only permissible in clear cases where a party has a witness under its control who would offer important testimony, yet is unexplainedly not called. Even when foundational conditions are met, the judge retains discretion to decline the instruction in light of its potentially severe adverse effect on the non-calling party. In Williams' case, the Commonwealth decision to avoid a compromised witness was reasonable, and the judge's refusal to instruct and to bar related argument was appropriate. Commonwealth versus Labelios. That's 2019. It's an appeals court decision. Labelios was tried for assaulting his girlfriend. He had two roommates who overheard parts of the incident. The Commonwealth called one, but not the second one, and they sought this instruction because he was essentially a missing witness. They argued that the prosecution's failure to produce the witness, who presumably was friendly to the Commonwealth, should permit an adverse inference. The trial judge denied that request, but did allow the defense counsel to comment on that witness's absence during closing arguments. The Massachusetts Appeals Court found no abuse of discretion in refusing the instruction. The court reasoned that the second roommate's testimony would have been largely cumulative of other evidence, the first roommate and physical evidence having already been established at that point. Moreover, ordinary logic and experience provided a plausible, non nefarious explanation for the witness's absence, his work family situation, so the Commonwealth should not suffer an inference of concealing evidence. Under those circumstances, it was proper to withhold the instruction. Notably, because the judge permitted defense counsel to highlight the missing witness in closing, the defendant was not deprived of the argument. Indeed, when counsel is allowed to make the point in summation, a formal missing witness instruction is not required. So, one of the things that Judge Bev can do here is she can allow Alan Jackson to make this missing witness issue a point in the closing argument, which would negate the ability or the requirement to give the instruction. In essence, it's just the lawyer giving the instruction, or suggestion, I guess would be a better way to put it, instead of the state. The appeals court held the trial judge acted within discretion in denying the instruction and permitting argument on the point. And then there's the Commonwealth versus Andrade, a 2020 appeals court decision. Andrade involved charges of bad conduct with children. The child victim told both parents about the problem on separate occasions, but at trial, the Commonwealth invoked the first complaint rule, allowing only one early report witness, and called only the mother to testify about the child's disclosures. The father, who had also heard that, was not called by either party. They requested an instruction, and they didn't get it. The appeals court agreed the instruction was properly refused by the trial judge. It held the defendant was not entitled to a missing witness charge because the father's testimony was not truly important or distinct in the context of the case. By law, the Commonwealth could only present one first complaint witness. Had the father been called, he could not testify to the child's out of court statements at all. Any other testimony the father might offer, peripheral observations, would have been limited value or have been merely cumulative of the mother's account. Thus, the prosecution would not naturally be expected to call him, and there was no basis to instruct the jury to draw a negative inference from his absence. The court emphasized that a missing witness instruction should be given only in clear cases and only with great caution because the inference implies that a party willfully withheld evidence. Furthermore, once the judge deemed the inference inappropriate, it was correct to foreclose the defense counsel from urging the jury to draw the inference in argument. Massachusetts precedent holds that the instruction and related argument rise and fall together. If the judge decides against the instruction, the counsel may not invite the inference in closing. In sum, the appeals court upheld the denial of the instruction as a proper exercise of discretion in light of the first complaint rule. But then we turn to Commonwealth versus Wilkerson, which is a 2020 Supreme Judicial Court ruling. Wilkerson was convicted of first-degree murder in a shooting. A cooperating witness, Burgess, not Shannon Burgess in this case, testified about events around the shooting and mentioned that Heather Ferris drove him home from work on the day of the crime. Ferris's account could potentially have corroborated or contradicted Burgess's story about the timeline, but the Commonwealth chose not to call Ferris at trial. So the defense requested this missing witness instruction due to the Commonwealth's failure to call Ferris, arguing her absence suggested her testimony would not support the state's case. The trial judge refused to give the instruction. Importantly, however, the judge did allow the defense to argue more generally that the Commonwealth presented no corroborating witness. For example, in closing, the defense pointed out that no one, including Ferris or others like an aunt mentioned in the testimony, was brought in to confirm parts of Burgess's story. This was framed as a general lack of evidence argument rather than an explicit reference or an explicit claim that Ferris would have been unfavorable to the prosecution. The Supreme Court ruled the judge's denial of a missing witness instruction was well within his discretion. It was certainly not manifestly unreasonable. And because Ferris's testimony was not of distinct importance to the central issues at trial, it wasn't deemed to be important evidence. At most, she could have refuted a minor detail about whether Burgess actually went straight home as he claimed, regarding her potential testimony largely corroborative rather than crucial. Supreme Court emphasized again that a missing witness instruction is a powerful tool that should only be given in clear cases and with caution. Judges have broad discretion in this area, and the appellate court's not going to reverse the decision absent manifestly unreasonable judgment. And they won't reverse Bev here in this case because there are apparently reasons for them not to call. Importantly, the Supreme Judicial Court drew a distinction between two scenarios: when a judge actually gives a missing witness instruction, in which case counsel may explicitly argue the adverse inference, and two, when no such instruction is given, in which case counsel may not ask directly for an adverse inference. However, even without the formal instruction, a defendant still has wide latitude to argue that the prosecution's evidence is incomplete or unpersuasive. In Wilkerson's case, defense counsel's closing argument about a lack of corroboration fell into this permissible category. It highlighted gaps in the evidence. Where is Heather Ferris? You don't have her testimony. There is no corroboration. So, again, there's no reason that in this case he can't say, where is Trooper Proctor? He's not here to give you his side of the story. There's no corroboration of what Yuri Buchanan is telling you. So, without directly telling the jury to infer Ferris would be favorable to the defense, the Supreme Court approved this approach, noting that the trial judge properly allowed a general absence of evidence argument while denying the specific missing witness inference instruction. In sum, the Supreme Judicial Court affirmed that refusing the instruction was appropriate given Ferris's limited significance, and the defendant was still able to press the point that the Commonwealth's case lacked certain evidence. So the case law presents a significant bar to the instruction, but not to the argument that a witness is not testifying, and pointing out that is a general lack of evidence. I would have been flummoxed if Bev allowed the instruction. Now, I have to say that this case is not on all fours with any of the cases cited by the Commonwealth or found in the case law with regard to Massachusetts law. And that's because Trooper Proctor engaged in what I would call prosecutorial misconduct in the way that he went about doing the investigation. Brian Albert and Brian Higgins acted in ways that are clearly culpable, or at least inculpatory, in that they destroyed their phones so that, again, you couldn't get that evidence or that information to use for impeachment purposes. And as a result, since they destroyed their phones, they they have a significant issue here, and there is this sort of, I would say there is a legitimate reason to argue the adverse inference in this case, and that's exactly what I'd point out. None of the case law is on all fours with this particular situation. They don't have a situation in any of these cases where the state or the state's witnesses deliberately, consciously, and obviously for some reason deleted evidence and impacted the ability of the state, and in this case, the defense, to prove their side of the case. So again, it's a good there's a good chance that there's a legitimate argument to make this claim, and to document it, get a ruling so that it goes into the record, and you can then argue it on appeal. But as I pointed out previously, the appellate courts in Massachusetts are where justice goes to deny in some cases. Uh, there's a case that I mentioned in one of my books about a woman who was confronted by her boyfriend he told her he was going to kill her and her children. He came down the stairs. She shot him because she was afraid for her life, and they convicted her of manslaughter. And the appellate court didn't reverse it and decided that, they thought the law in the way it was in Massachusetts was just fine. They sort of have this view that if it wasn't invented in Massachusetts, or if it's an argument that came out of case law from some other state, that, well, it has no place here in Massachusetts because we're special. So I don't know where they're going with this, and I don't know what the end result will be, but I know that if I was arguing this case, I would quite likely, uh, say, in closing argument, I would point out that there are names you have heard that you have not heard from in this case. We didn't call them because they're not our witnesses, and I would leave it at that. Or Actually, what I may wind up doing, and you guys tell me if you think this is a good idea. I think what I might very well do is do a closing argument. The closing argument that I would do in this case, and again, it's sort of based on my limited knowledge of all the facts. I'm sure Mr. Jackson will just blow it out of the water. But I might do, I would probably do 3 videos, 20 minutes each to break up the hour so that, again, I'm not overloading YouTube and that you're not going to have to sit for an hour and listen to me drone on. That's what I might do. If anybody is interested, please let me know in the comments if you are.
That's what I have for you today. I hope you found it helpful, interesting, or maybe both. If there's a subject you'd like me to discuss, please feel free to send me an email at the address above. If you like what we do, please feel free to subscribe and come on back to the beach tomorrow. I release videos every weekday, weather and work permitting. If you have the opportunity today, do a kindness for your fellow man. It makes the world a better place, one kind act at a time. And now, YouTube has some suggestions for other videos of mine that you might like.